The House Appropriations Committee will come to order for the purpose of public hearing. We're going to just run down the list as they're listed on the agenda, and we'll begin with a staff briefing on Substitute House Bill 1232. I believe we have Mr. Patton and Ms. Stevens here to brief us. Good afternoon.
This is Corey Patton, staff to the Community Safety Committee. Substitute House Bill 1232 is a bill that relates to the regulation of private detention facilities. For context, a detention facility is a facility in which persons are incarcerated or otherwise involuntarily confined for certain purposes. Those purposes include holding people prior to trial or sentencing, for the purpose of fulfilling the terms of a sentence, or for other judicial or administrative proceedings. Meanwhile, a private detention facility specifically is currently defined in statute as any detention facility that is operated by a private, non-governmental, for-profit entity pursuant to a contract or agreement with a federal, state, or local government. In 2023, the legislature enacted House Bill 1470, which prescribed certain operational standards for private detention facilities, with some of those standards only applying to facilities that had contracted on or after January 1st, 2023, or otherwise extended or modified existing contracts on or after that date. House Bill 1470 also provided for inspections of such facilities by the Department of Health and the Department of Labor and Industries, created private rights of action and civil penalties for violations, and exempted certain categories of facilities from those regulations. However, in 2024, the United States District Court for the Western District of Washington partially granted a preliminary injunction that enjoined the state and its agencies from enforcing the provisions of HB 1470 against the operator of the Northwest Ice Processing Center. The bill before you, Substitute House Bill 1232, amends the definition of private detention facility to mean any detention facility that is operated by a private, non-governmental entity pursuant to a contract or agreement with a federal, state, or local government entity, and as regardless of whether the detention facility is operated for profit. The bill also modifies 4 main categories of provisions related to the regulation of private detention facilities, and those 4 categories are the operational standards for such facilities, inspections of such facilities, the civil penalties for violations involving such facilities, and exemptions for certain types of facilities. I'll address each of those briefly. First, with respect to operational standards, the bill requires the Department of Health to adopt specified rules about the minimum standards for the physical environment, services, equipment, and policies that private detention facilities must maintain. A full list of what must be provided can be found on pages 4 and 5 of the written bill report. The bill also modifies the additional standards that apply only to facilities that contracted on or after January 1st, 2023. Broadly speaking, these additional standards pertain to food service and dietary requirements, access to telecommunication and visitation, policies and procedures to protect against abuse and neglect, faculty staffing, and safety planning. Again, a full list of these standards is provided on pages 5 and 6 of the written bill analysis. Second, with respect to inspections of facilities, the bill authorizes the DOH to inspect private detention facilities at any time to determine whether they have failed or refused to comply with applicable state or federal law. As resources allow, the bill also requires the DOH to make specified information about these inspections available online. Third, with respect to civil penalties, the bill authorizes the DOH to take corrective action against non-compliant private detention facilities under specified circumstances. If a private detention facility has been previously subject to a corrective action for a similar type of violation, has been given any previous statement of deficiency for a similar type of violation, or has failed to correct its non-compliance by an agreed or established date, then the DOH may either impose reasonable conditions on the facility or assess a civil fine of up to $10,000 per violation, not to exceed a total of $1 million. Proceeds from those fines may only be used by the DOC to provide training or technical assistance to private detention facilities, and the DOH must adopt rules specifying the amounts for those fines in relation to the severity of noncompliance. Fourth and finally, with respect to exemptions from these regulations, the bill amends an existing statutory exemption that applies to juvenile facilities. That change is made to instead provide that the exemption applies to facilities that provide counseling, treatment, mental health, educational, or medical services to juveniles pursuant to specific licenses issued by the Department of Children, Youth, and Families. That concludes my remarks. I'll turn it over to Ms. Stevens.
Thank you.
For the record, Emily Stevens, staff to the committee. There is a fiscal note in your EBB for the original bill. A fiscal note for the substitute bill has been requested but isn't yet available. The Department of Health anticipates undergoing complex rulemaking to adopt standards related to sanitation and hygiene for individuals detained in private detention facilities as required under the bill. They estimate needing 1.5 FTEs over 2 years to complete this process at a total biennial cost of $542,000. Beginning in fiscal year 28, DOH also estimates needing 1.5 FTEs to conduct the 2 inspections per year for juvenile private detention facilities. They estimate staff costs of $334,000 per year. Last, DOH anticipates receiving about 500 complaints per year for the juvenile detention facility covered under the bill. Beginning in fiscal year 28, DOH estimates needing 1.5 FTEs to investigate these complaints, and they estimate $313,000 per year in ongoing staff costs. DOH also estimates about $70,000 for services from the Office of the Attorney General. The total cost to implement this bill is $542,000 in the 25-27 biennium and $1.3 million in the 27-29 biennium and ongoing, all from general fund state. And that concludes my remarks.
Excellent. Thank you both very much for the briefing. Any questions for Mr. Patton or Ms. Stevens? No questions. Thank you. Before we begin calling folks up, this hearing is being taped and live streamed on TVW. For those folks in the room, please speak directly into the microphone, identify yourself before you begin, and any organizational affiliation you have. Today's timing, given our bill load and the number of folks interested in these policies, will be 1 minute. Spoiler alert is that goes a lot quicker than you might think ahead of time. So you will see the little traffic light device in the front. It will be green for the first 30 seconds, yellow for the second 30 seconds, and then when it turns red, please conclude your remarks. For those folks online, a timer will appear in the upper left of your screen. Please keep an eye on it and conclude your remarks. And please wait to give your remarks until you've been recognized by Vice Chair Macri, and Vice Chair Macri will be calling up panels both in person and online.
Great, thank you so much, Mr. Chair. So we'll proceed with our online testifiers on House Bill 1232. So if we could have Jean Hill, Kristen Ong, and Christina Walker. And Kristen, why don't you please go ahead?
Good afternoon, Chair Ormsby and Rep. Macri and members of the committee. My name is Kristen Eng, Policy Director of Faith Action Network, a statewide multi-faith coalition, here in strong support of House Bill 1232. For years in my area in particular, as a resident of Tacoma, the Northwest Detention Center has been the site of serious human rights concerns, including inhumane living conditions, inadequate medical care, prolonged solitary confinement, and the barring of oversight agencies from entry, particularly last year. Detained individuals have resorted to hunger strikes at great personal risk because their voices have been ignored. Solitary confinement is regularly used in troubling ways, leading to severe mental and physical harm, while oversight agencies like the Department of Health and Department of Labor have been denied access to investigate complaints of abuse and leaving these detainees isolated. We urge passing of House Bill 1232 to ensure transparency, oversight, and fundamental human dignity. We ask that these state protections, and for all people that are currently residing here in Washington State, thank you for your consideration.
Thank you.
Thank you. Jean, welcome. Please go ahead.
Thank you so much. Jean Hill with the Washington State Catholic Conference, also in strong support of this particular bill. HB 1232 is one of those appropriations that really helps you protect the most vulnerable. Heat, light, food, healthcare. No matter a person's legal status, these are the necessities to sustain life. No private for-profit contractor should be allowed to ignore or jeopardize the basic dignity of life for any human person. We urge your support for HB 1232, which provides guardrails on the use of private for-profit entities to care for people who may have done little more than seek a better life in a country with massive wealth and the means to provide for basic needs. As long as the federal government continues to commodify human life through the use of private prisons, this bill is a necessity. Thank you so much.
Thank you.
And Christina, please go ahead.
Thank you. Good afternoon, Chair and ranking members, committee members. I'm Councilmember Christina Walker from the City of Tacoma, and I'm here today also testifying in support of House Bill 1232. The privately run Northwest Ice Processing Center is located in Tacoma, as you know, and I've been working actively over the years to understand the experiences of those detained in this facility. While I've heard countless horror stories about conditions in this facility, from prolonged solitary confinement to food that is infested by worms, our City Council lacks the authority to intervene. We need the state to allow the Department of Health to ensure that state and federal laws are being upheld and to take enforcement action against non-compliant facilities. I recognize that our state budget issues are serious. However, the fiscal impact of this bill is a small price to pay to ensure that Washington State remains a leader in safeguarding human rights. I appreciate the work of Representative Ortiz-Self on this important issue, and I appreciate the time to speak today. Thank you for your support.
Thank you, Councilmember. Vice Chair Macri.
Those are all our testifiers on this bill.
Thank you very much. That will conclude the public testimony on Substitute House Bill 1322. I would now request a staff briefing on Substitute House Bill 1303 from Mr. Lipson and Mr. Jones. Good afternoon.
Good afternoon, Chair Ormsby, members of the committee. Jacob Lipson, staff to the Environment and Energy Committee. Substitute House Bill 1303 adds environmental justice to the State Environmental Policy Act. A couple quick bits of background. First, the State Environmental Policy Act, or SEPA, provides a process for lead government agencies to consider environmental impacts of the government action and to consider, condition, or to deny that action based on that environmental review. Lead agencies under SEPA can be both state agencies or local governments. A key juncture in the SEPA process is when a lead agency makes what's known as a threshold determination regarding whether there will be an anticipated significant adverse environmental impact. Also worth noting, under the 2021 law known as the HEAL Act, certain state agencies are required to take certain actions to consider environmental justice in their decision-making and budgeting, and to carry out an environmental justice assessment associated with certain significant agency actions. Under the bill in front of you, Substitute House Bill 1303, Department of Ecology must adopt rules to include environmental justice as an element of the environment considered under SEPA review, and adding it to the checklist filled out by project proponents prior to a threshold determination. Ecology under the bill is directed to adopt standardized mitigation for environmental justice impacts under SEPA, which when implemented would be considered in a threshold determination. These requirements are additional to the requirements of the 2021 HEAL Act, but a covered agency may use an environmental justice assessment or other documents prepared under the 2021 HEAL Act to the extent those are able to satisfy the obligations under SEPA.
Good afternoon, Dan Jones, staff to this committee. In the Department of Ecology's fiscal note, they estimated total cost of about $1.5 million the first biennium and about $500,000 per biennium after that. The $500,000 in ongoing costs are for staff to identify ways to mitigate potential impacts to environmental justice, and also to review environmental justice assessments from other agencies and provide training and assistance. The $1 million in one-time costs is for rulemaking, which Ecology assumes would take at least 2 years. Ecology assumed general fund state for their costs, but the Climate Commitment Act would be another option. There are also indeterminate costs from the bill across multiple agencies when they're acting as a SEPA lead agency, including Ecology, for additional SEPA-related workload. And that concludes my remarks.
Thank you both very much. Are there any questions for Mr. Lipson or Mr. Jones? No questions. Thank you both very much. Representative Macri for public testimony.
Thank you, Mr. Chair. We have a number of people in the room and a few online as well. So I'm going to call up our in-person folks here. Guillermo Rogel, Corey Shaw, and J.C. Harris. And then to get ready online, if we could bring in John Worthington, Jean Hill. Oh, and that's all I think we have here online. So Rogelio, Guillermo, please go ahead.
My high school teacher used to call me that. Chair Ormsby, members of the committee, my name is Guillermo Rogel, here with Front and Centered. We're a network of 50 community-based organizations across the state working towards a just transition here across the state. We are led by communities of color and low-income populations, and I just want to take you all back to 2021 when we passed the HEAL Act. On top of defining environmental justice and making sure we were all operating under the same definition, this fundamentally changed how we approach climate policy and also invest our climate revenue. We see 1303 as a follow-up to the HEAL Act, where we are embedding an environmental justice analysis into the SEPA process. There currently is no way to capture the community and health impacts of different projects and facilities. So we're hoping that this bill helps advance environmental justice here in the state of Washington. We did make some changes in the first committee. We're hoping that that's reflected in the new fiscal note that staff covered, but really urge your support and just thank you all last week for meeting with our members who came for Advocacy Day. They had a great time meeting with a lot of you all. Thank you.
Thank you.
And Corey, go ahead.
All right, thank you, members of the committee. My name is Corey Shaw. I'm the Executive Director of the Washington Aggregate and Concrete Association. And we do want to state that we do environmental evaluations in all of our SEPA processes, and some of those questions do include impacts to the surrounding neighborhoods and communities. That would be Section 7 of the checklist. So for our perspective, increasing the permitting timeline and increasing the cost to do business would just be a challenge for our members, and we just feel that this at this time is not the best thing to do moving forward, since we already are including those into our conversations for our projects. So thank you. I would ask that you not pass the bill.
Thank you.
Thank you. And JC?
Good afternoon. My name is J.C. Harris. I represent Sea-Tac Noise.info, a community organization. As the name implies, people impacted by the 8th largest airport in America, which is now undergoing between $5.5 and $8 billion in capital improvements, and there is zero mitigation or compensation required either under NEPA or the expected SEPA. This bill is the logical extension to fill a gap. We rank 9 and 10, meaning we are the most impacted environmentally communities in the state, and yet we have no mechanism without legislation like this. Thank you.
Thank you.
And if I can call up the other two testifiers, or three testifiers who are here in the room, Jan Heimbaugh, Kelsey Hulse, and Peter Godlewski. And we'll turn to our online testifiers now, starting with John. Please go ahead.
John Worthington Squim. I'm against the bill because the shipping emissions continue to evade review by the Department of Ecology. Previously, I challenged the pollution sources of a lot of these communities of color, disadvantaged communities. They had no answer to the 600 or actually almost 700 mile an hour jet stream that blows away from where their pollution sources are alleged to be. The folks at Sea-Tac, the Department of Health, said they could live there just fine in 1999. 20,000 more people later, we're trying to go back and scratch that itch, which is a terrible decision. They should be all located in South Center, but they decided to build sound transit to the airport and invite more people to live there. How does a coastal tribal community get polluted through a jet stream? And how would the ships not be responsible for that? It just needs a lot more work.
Thank you so much. And we'll now turn to Jean Hill. Welcome back.
Thank you. And I promise I'm not testifying on every bill. Jane Hill with the Washington State Catholic Conference, and we are in support of HB 1303. We really welcome the framework proposed in this bill, which takes into account the cumulative environmental public health stressors experienced by overburdened populations. We know that certain populations disproportionately bear the effects of pollution. This bill is an opportunity to address this injustice and protect life from the effects of pollution. The bill calls for deeper analysis of who is impacted and who is repeatedly impacted. We also support the opportunity for members of the community to be given a voice when new projects are seeking permits or permit renewal. The Bishops of Washington State, thank you for your work to care for our common home, and we ask you to pass 1303 out of committee. Thank you.
Thank you.
Thank you. And welcome, Jan. Please go ahead.
Thank you. Good afternoon. My name is Jan Heimbaum here on behalf of the Building Industry Association of Washington, here in opposition to House Bill 1303. You know, Washington has done a lot recently when it comes to building residential homes and units for buildings, and this actually will hinder the ability for more housing units to go in. We have a robust SEPA process which takes into account all sorts of different environmental impacts, built environment, health of the environment, the actual environment, health, air. I think adding an additional check mark to the list or checklist, addition to the checklist, is going to put projects back and make them more expensive and make them harder to build for housing our communities. Thank you.
Thank you. And Kelsey.
Hi. Thank you. Good afternoon, Chair Ormsby, Ranking Member Couture, and members of the committee. My name is Kelsey Hulse, and I'm here today on behalf of the Washington State Association of Counties and the Association of Washington Cities. We're deeply supportive of the underlying intent of HB 1303 and appreciate the sponsor's work to center environmental justice in the broader legislative and regulatory landscape. We're signed in other today in recognition of the work the sponsor has done and the improvements in the overall direction of the bill. We're concerned about the impact of requiring an EJIS prior to a threshold determination due to the level of analysis involved for a project that may not ultimately be impactful. Some of our members have also expressed that they feel unprepared or unqualified to assess environmental justice impacts. Lastly, we're also concerned about the cost to implement the bill as written. The local government fiscal note is non-zero but indeterminate, but we can be pretty sure that the results would be impactful and something that local jurisdictions would not be able to control. We'd be happy to provide more detailed feedback, but we would love to continue the conversation with the sponsor in the interim and explore how best to make environmental justice not just an item on a checklist, but a guiding principle for how we plan for it and build our communities.
And welcome, Peter.
Thank you. Good morning, Chair, or good afternoon, Chair Ormsby, members of the committee. For the record, Peter Godlewski with the Association of Washington Business, also signed in opposed this afternoon. Would like to echo the comments of the previous panel. We do appreciate the work of the prime sponsor in addressing the concerns about the original draft and sort of the narrowing down of this bill. Do still have some concerns about the impact on project timelines and also sort of the wide open-ended nature of what environmental justice would be in the context of SEPA, which we think needs a little bit more development and work. And then also would like to really emphasize what was just previously said about the cost impacts to the local jurisdiction. Many SEPA projects do go through local lead agencies. The cost that they are going to bear and the expertise they may or may not have is a considerable concern to the permitted community. We do think that this does have some additional concerns and would look forward to some additional conversations. Thank you.
Thank you.
Thank you very much, and those are all our testifiers.
Thank you, Vice Chair Macri. So that will conclude the public hearing on Substitute House Bill 1303. And would request a staff briefing on House Bill 1309. I believe we have Ms. Lewis and Mr. Jones. Good afternoon.
Good afternoon, Mr. Chair, members of the committee. Rebecca Lewis, staff to the House Agriculture and Natural Resources Committee. The bill before you is House Bill 1309, creating an integrated pest management research program at the Department of Agriculture to address impacts of burrowing shrimp on bottom culture shellfish farming. By way of brief background, there are several agencies with roles related to permitting and regulating shellfish farming in Washington, including the Departments of Agriculture, Ecology, Health, and Fish and Wildlife. In 2018, the Department of Ecology denied a request by shellfish growers to use the pesticide imidacloprid on shellfish beds to control burrowing shrimp in Willapa Bay and Grays Harbor. In 2019, Ecology and the Willapa Bay Grays Harbor Oyster Growers Association signed a settlement agreement to study and monitor the impacts of burrowing shrimp on commercial oyster and clam harvesting in the area. And in the 2023-25 operating budget, the Department of Agriculture received funding for research on a suitable replacement for imidacloprid to address the impacts of burrowing shrimp on shellfish cultivation in Willapa Bay and Grays Harbor. Turning to the bill before you, House Bill 1309 directs the Department of Agriculture to establish and administer the burrowing shrimp research program with the governing board and a non-appropriated account to recommend funding for research to address burrowing shrimp infestations and facilitate and enhance collaboration among various parties, including researchers, shellfish farmers, and regulatory agencies. The bill enumerates responsibilities of the program to meet these goals, including soliciting researchers for research projects and providing permitting assistance. The bill also requires the director of the Department of Agriculture to collaborate with certain entities to appoint members to the governing board. Governing board members must have specific expertise and a state or vested interest in the shellfish industry and represent certain state agencies, shellfish growers, and other representatives of the shellfish industry as are listed in the bill report. The program and account would expire on June 30th, 2035. And with that, I'll turn it over to Dan for the fiscal briefing.
Good afternoon, Dan Jones, committee staff. As Rebecca mentioned, the bill creates a new non-appropriated account called the Burrowing Shrimp Research Account. There is intent language in the bill for the legislature to appropriate $2 million per biennium from the Model Toxics Control Operating Account into the Burrowing Shrimp Research Account. So the cost of the bill depends on how much the legislature chose to put into the new account. The new account could be used to cover agency costs, which include meetings of the governing board for multiple agencies, as well as Department of Agriculture costs to develop a management plan and oversee grants and contracts. Then whatever is left over in the account after agency costs could be used for funding burrowing shrimp research projects. So in the example of the fiscal note, if $2 million were put into the account next biennium and agency costs were funded at $260,000, there would be up to $1.7 million available for the research projects. Finally, I note that if you look at the fiscal note, some agencies assumed general fund state and some assumed the new account for their costs, but all of those costs could be from the new account. And that concludes my remarks.
Excellent. Thank you both. Questions for Ms. Lewis or Mr. Jones? No questions. Thank you both very much. We'll now go to public testimony. Vice Chair Macri?
Thank you, Mr. Chair. I'll ask our first group of in-person, or only group of in-person, to come up. Marilyn Sheldon and Kathleen Nisbet-Monsey. And we'll get our online testifiers in the room. Darlene Schoenfeld, John Worthington, and Marilyn Schollwater. And as our testifiers come up, yeah, we'll let you go first. Welcome.
Great, thank you. Chair Ormsby, Ranking Member Couture, members of the committee. Thank you for the opportunity to testify today. My name is Marilyn Sheldon. I'm here with the Willapa Bay Grays Harbor Oyster Growers Association. My husband Brian and I own and operate Northern Oyster Company in Willapa Bay, Washington, and we farm bottom culture, clams, and oysters. Shellfish farming has played a vital role in Washington's history and economy for generations, particularly in rural communities such as Willapa Bay and Grays Harbor. The industry not only generates significant revenue, but it supports thousands of jobs in areas where economic opportunities can be limited. Additionally, shellfish farming plays an essential role in Washington's broader economy, with exports worth hundreds of millions of dollars annually. Burrowing shrimp threatens the viability of our shellfish farms. The funding in this bill is crucial to continue research and refine control methods, ensuring shellfish farmers have the tools to protect their livelihoods and the environment. By supporting the Integrated Pest Management Working Group, you will sustain this momentum.
Thank you very much.
We respectfully urge you to support this important work. Thank you.
Thank you. And I see that Kathleen Nisbet-Monsey is actually online and not in person. So Kathleen, why don't you please go ahead?
Thank you. Chair Ormsby, members of the committee, thank you for the opportunity to testify today. My name is Kathleen Nisbet-Monsey, and I'm with the Willapa Grays Harbor Oyster Growers Association. My family owns and operates Goose Point Oysters and employ around 100 full-time men and women on our 1,900-acre farm and processing plant. Shellfish farming has been a cornerstone of Washington's rural economy, especially in the communities around Willapa Bay and Grays Harbor since prior to Washington being a state. These areas have supported multi-generational families in the shellfish industry for decades, and the sector itself continues to contribute hundreds of millions of dollars annually to Washington state's exports. It is a critical employment and is a key driver of our local community here, as shellfish growers are the largest private employer. However, we've been faced with the issue of burrowing shrimp for the last 60 years, and we do not currently have a control method. In recent years, thanks to funding of the legislature, the IPM working group has been able to research alternative methods for controlling this infestation. If we are able to do this, these funds will allow us to build the ongoing efforts, expanding research into new techniques, and improving our ability to effectively manage this issue. Thank you for continuing to support Washington's shellfish industry.
Thank you.
And Darlene, please go ahead.
Yes, my name is Darlene Chadfall. As one citizen expressed, this bill allocates $2 million of scarce funds to study how we can treat a valuable part of nature as a pest rather than as an asset. Yet we wonder why the health of these systems continue to decline. We should not be spending MATCA money needed for hazardous waste cleanups on this industry, nor allowing the use of pesticides and mechanical tanks to destroy natural habitat, nor a board to run the State Department of Ag instead of an advisory committee. Willapa and Grays Harbor Base both abut national wildlife refuges. What happens to the base happened to the wildlife refuges. Additionally, these two sites are known for being exposed to sewage runoff, risking shellfish unhealthy for consumers. Please do not pass this bill. Oppose it.
Thank you.
Thank you. And John, welcome back. Please go ahead.
Thank you, Madam Vice Chair, committee members, John Worthington. I solemnly testify against this bill because Washington State has a problem with adopting a mitigation strategy on some rivers and a natural policy on others. I prefer a mitigation strategy, but it's not fair to the homeowners that Washington State has flooded out, in my opinion, intentionally by adopting a natural river management system, except in places like where the tribes are located, and give them a huge advantage. It's time to step up and say it's mitigation now and forever, or it's natural now and forever. That means you have to decide that you're going to apply mitigation equally. And I don't mind. But what I do mind is you're flooding people out under the auspices of natural while other people get protection for their properties with mitigation. Thank you.
Thank you.
Thank you so much. Marilyn, welcome.
Yes, I'm Marilyn Showalter. I live in Jefferson County on Hood Canal. I'm opposed to the bill. This is a bit of a homecoming for me. I am a former legal counsel to the House Appropriations Committee.
Welcome back.
I have also served as a chief clerk of the House, counsel to the governor, and chair of the Washington Utilities and Transportation Commission. In those respects, I am familiar with the constitutional prohibition against gift of public funds, and also familiar with regulatory capture, where the regulated agency attempts to unduly influence who regulates it. This bill is a parody of self-dealing. It creates a board overwhelmingly controlled by the shellfish industry that then directs, that's a quote, the director to carry out the instructions of the committee for the benefit of the shellfish industry. I have written further comments in your book.
Thank you very much.
Thank you. And those are all our testifiers.
Well, thank you, Vice Chair Macri. That will conclude the public hearing on House Bill 1309, and would now request a staff briefing on Substitute House Bill 1399. I believe we have Ms. Langer and Ms. Jeffrey joining us this afternoon for that. Good afternoon.
Thank you, Mr. Chair and members of the committee. For the record, Lena Langer, staff to the Community Safety Committee. Substitute House Bill 1399 concerns sheriffs, police chiefs, marshals, and police matrons. By way of background, actually, in the interest of time, I will not provide the background I usually would, but I will mention briefly that eligibility requirements for police chiefs and marshals are on page 2 of the bill report. Sheriffs must obtain certification from the Criminal Justice Training Commission, or CJTC, within 12 months of assuming office. Sheriff's duties are enumerated in statute and can be found on page 3 of the bill report. Additionally, a peace officer or corrections officer applicant who has a conditional employment offer must submit to a background investigation. The current background investigation components are included on pages 3 to 4 of the bill report. Turning to Substitute House Bill 1399, I will brief 5 main changes made by the bill. First, eligibility criteria for appointment as police chief or marshal are amended so that the same requirements apply for the position for any city or town regardless of size or class. New or amended criteria for appointment as police chief or marshal provide that the person must be age 25 or older, have not been convicted under foreign law of the equivalent to a felony, have not been convicted of a gross misdemeanor involving moral turpitude, dishonesty, fraud, or corruption at any time, have not engaged in conduct meeting the criteria requiring denial or revocation of certification, have at least 2 years of regular full-time law enforcement agency employment with a government law enforcement agency, have obtained certification within 12 months of assuming office unless extended by the CJTC, and if not yet certified, have met the CJTC background investigation requirements for peace officers, and if certified, have met background investigation requirements within 6 months of appointment, confirming that the person meet the eligibility requirements outlined in the bill. Eligibility criteria regarding discharge from military service, a high school diploma or equivalent certificate, and citizenship are unchanged. Current police chiefs or marshals at the time of the effective date are not required to meet background investigation requirements unless they seek appointment to a different department. A vacancy is created if the person does not maintain certification, is decertified, or other eligibility requirements are not met. Second, that was all just the first point. Second, a person filing for candidacy for sheriff or seeking appointment must meet the same eligibility requirements as police chiefs or marshals. If the person is not yet certified, the person must meet the CJTC background investigation requirements for peace officers. If certified, the person must meet background investigation requirements within 6 months. The person filing for candidacy must submit a background investigation request to the Washington State Patrol at least 2 months before the filing deadline. The Washington State Patrol must submit the completed background investigation to the CJTC for verification at least 45 days before the filing deadline. The CJTC must post a list of all candidates for sheriff who have passed the background investigation. The same provisions apply as they did for chiefs and marshals regarding current sheriffs and vacancies in the office. The duties of the sheriff are amended. In the interest of time, please see page 6 of the bill report for a list. Third, if a law enforcement agency or sheriff's office uses volunteers or specially commissioned officers, unless they are certified, the volunteers or specially commissioned officers may not engage in actions involving use of law enforcement authority, carrying or use of firearms or other weapons, or tracking with dogs other than for search and rescue. Volunteers and specially commissioned officers may assist with other functions, including helping with traffic management. Fourth, concerning changes for the CJTC generally and background investigations, the CJTC must prioritize giving sheriffs, chiefs, and marshals access to training required for certification. Law enforcement or correctional agencies that previously employed or received an application from an applicant must disclose employment or application information within 30 days of receiving a written request from an employing agency conducting a background investigation. Officers must indicate any prior application material and background investigations conducted while seeking employment with other law enforcement agencies. By August 30th, 2026, the CJTC must issue guidelines with criteria for counties, cities, agencies, and the CJTC to apply in determining whether an applicant is suitable for employment. In developing the guidelines, the CJTC must seek input from individuals who have experience in reviewing law enforcement background investigations and others. For a list of individuals, please refer to the bill report on pages 7 to 8. The CJTC must include summary records of certification revocations obtained via default or surrender, certification denials, and all cases that were resolved with disciplinary action annually on its website. Finally, the chapter relating to police matrons is repealed. That concludes my remarks.
Thank you very much.
Good evening, Mr. Chair, members of the committee. For the record, Sydney Jeffrey, staff to this committee. Moving to the fiscal impacts, there's a fiscal note available in your EBB for substitute House Bill 1399. The total estimated cost across all impacted agencies is $598,000 in the 25-27 biennium, $277,000 in the 27-29 biennium, and $571,000 in the 29-31 biennium, all of which is NGFO. Changes in the bill will require additional legal services requests of the Attorney General's office. The agency estimates that new legal services will be nominal and at present can be absorbed within current expenditure authority. Washington State Patrol assumes one sheriff's candidate investigation per county during each county's respective election year, resulting in 35 candidate investigations in fiscal year 2026, 2 in fiscal year 2027, and 1 in fiscal year 2028. 2028, assuming the costs associated with these counts, the State Patrol estimates a fiscal impact of $268,000 in fiscal year 2026, $94,000 in fiscal year 2027, and $47,000 in fiscal year 2028, with this pattern repeating every 4 years in alignment with election cycles. The agency estimates expenditures predominantly impacting the transportation budget State Patrol highway account, with $72,000 in general fund state dollars and $229,000 in State Patrol highway dollars, for a total of $302,000 in the 25-27 biennium. The Criminal Justice Training Commission, or CJTC, estimates a fiscal impact of $297,000 in the 25-27 biennium and $270,000 per biennium thereafter. Initial costs are for one-time consultation from psychologists and polygraphers as the agency develops the best practice standards, 1 FTE to review and verify background checks for sheriff's, chief of police, and marshal candidates, and one-time equipment costs for the additional FTE. Ongoing costs are associated with the salary and benefits of the additional staff person. In addition to these estimates, there are indeterminate costs to local governments regarding any fees associated with background checks, limitations of authority put on volunteer and specially commissioned officers, and record retention of applications. Overall, the bill would require that law enforcement agencies make changes to their hiring practices, record keeping, and use of volunteers and specially commissioned officers. The required changes will vary across jurisdictions, and therefore the total impacts are indeterminate. And that concludes my remarks.
Excellent. Thank you both very much. Questions for Ms. Langer or Ms. Jeffrey? Representative Penner.
Thank you, Mr. Chair. If I understand this bill correctly, it changes where the oath of office is sworn, or at least it specifies the state of Washington, not the United States. But also in that statement talks about interpreting and applying, how those laws are interpreted and applied by the state Supreme Court. Are all laws interpreted and applied by the state Supreme Court? Is that clear for potential sheriffs?
So I think you're referring to the duties of sheriffs, which is amended to say to enforce the Washington state constitution and laws as applied or interpreted by the state Supreme Court. So the bill doesn't reference the oath, but that is, I think, the part that you're referring to.
Representative Couture.
Thank you, Mr. Chair. Lena, in Section 15, it repeals a few different acts, one of them being RCW 3566050, persons under arrest in separate quarters. Can you explain to us what that repeal means in reality?
So Section 15 is repealing the chapter relating to police matrons. So all of these sections are referring to police matrons. Would you like me to talk more about? I would love to talk more about police matrons. I actually did look this up. So police matrons were assigned with overseeing females that were arrested and detained in jail.
Thank you for that.
They're older statutes. Yeah. Oh, and also I wanted to correct, in my briefing, I said that the CJTC must issue guidelines by August 30th, but it's June 30th, and I don't know why I said August.
Understandable. Are there any other questions? Thank you both very much for your in-depth briefing, and we'll now go to public testimony. Vice Chair Macri.
Thank you, Mr. Chair. I'll call up our in-person testifiers, James McMahon and Dawn Land, and then online, if we could have Sharon Byrne, April Morrow, and John Axtell to begin. And James, please go ahead. Welcome.
Good afternoon, Mr. Chair and members of the committee. I'm James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs, here to testify opposed to House Bill 1399. We do not oppose minimum standards for sheriffs and police chiefs. We are troubled that our planned meeting with the prime sponsor of the bill was canceled 2 days after we submitted a counter proposal to the bill, and we've not been allowed to negotiate the provisions of this bill since. We believe that at least two provisions of this bill violate sections of the Washington State Constitution, that being Article 1, Section 19 and Article 1, Section 33. We shudder to think of the public safety ramifications of the language requiring sheriffs and their deputies to enforce all laws of the state of Washington, and we think you should too. We fear for the public safety consequences regarding the language about the use of volunteers and specially commissioned deputies, and we remain ready to sit at the table to negotiate this policy if we are allowed to be heard.
Thank you.
Thank you so much. And Dawn, welcome.
Thank you. My name is Dawn Land, and I'm asking you to vote no on House Bill 1399 today. Section 15 of 1399 repeals the legal requirement for our prisons to be segregated by sex. This would be very expensive for Washington State. Our state currently allows males who claim to be women to be housed in the women's prison in Purdy, and we have already seen financial repercussions of these dangerous policies. Last year, Mazi Clark Sanchez filed a federal lawsuit against the DOC after being locked in a cell with Christopher Williams, a fully intact male who sexually assaulted her many times. If Section 15 is made law, it would make our prisons fully co-ed. The need for condoms, birth control, prenatal care will drain the DOC budget while the number of lawsuits skyrocket. An article in the Tennessee Star revealed how many male inmates are claiming to be women so they can be housed with women. Their intention is to impregnate incarcerated females and create a $1 million baby when the woman sues the state. Section 15 is the $1 million baby portion of this bill. Washington State cannot afford 1399. Please vote no.
Thank you very much. And now we'll turn to our online testifiers, starting with Sharon. Please go ahead.
Thank you. I'm with the Women's Liberation Front, and we oppose this bill. Does the state of Washington
can you just state your name for the record?
Sure, Sharon Byrne. Does the state of Washington intend to violate international human rights law, the Universal Declaration of Human Rights, and the Nelson Mandela minimum rules for treatment of prisoners by committing a heinous state-authored assault on the human rights of females in your custody? You are legislating the mass rape of incarcerated women and deliberately deceiving the good people of Washington by inserting one line at the bottom of this bill on sheriffs that repeals the code requiring prisoners be housed separately by sex. We doubt the sheriffs have pleaded with you to do this. Perhaps the subversive attempt to make Washington jails and prisons co-ed without the public's knowledge arises from the lawsuit filed against you by Mazi Clark, raped by a biological male and convicted sex offender Christopher Williams after the state placed him in her cell. You're going to unleash mass-scale rapes with this and make your correctional facilities co-ed. Legislators, please be at least honest with your constituents and create a standalone bill or a ballot initiative so the good people of Washington know you plan to put men in women's prisons instead of hiding it in the bottom of a sheriff's bill. It is impossible to estimate and truly appropriate the awful human.
Thank you very much.
Incarcerated women that you will.
Thank you, Sharon. April, please go ahead.
Hi, my name is April Morrow, founder of Sovereign Women Speak. I'm an advocate for 550 plus women inside Washington Correctional Center for Women who are being forced to live and shower with highly violent criminal males who have raped, murdered women, and molested children. Many female inmates suffer from PTSD from being raped and molested or abused before they were ever incarcerated. This is unjust, reckless, and dangerous. It's also very expensive. It also violates 3 of the women's constitutional rights. Housing males that identify as women, they have a Y chromosome that will never turn into an X, no matter how long they grow their hair, how much makeup they wear, or how many hormones they take. The women inside of WCCW are being traumatized by these men. I highly suggest that you read Trans by Helen Joyce, and Irreversible Damage by the Transgender Craze Seducing Our Daughters. I ask Washington State to please vote con on this bill. Thank you.
Thank you, and we'll now turn to John.
John Axtell, taxpayer protected by my sheriff alone. Decisions are best made by people closest to the problem. Legislators and commissioners should recommend but not decide anything. Anyone who has the tenacity to consider that the requirements of a police chief in Spokane or Seattle needs to have the same requirements as a police chief in a small town with 150 people in it is delusional. We need to let the people that elect the people that elect sheriffs control the sheriffs, not a committee, not legislators. You don't understand my problems. You don't understand the problems of our sheriff, and you don't understand the problems of our county. Let us be and defeat this insanity. Thank you very much for your time, and best of luck.
Thank you, John. And we'll now turn to our last number of testifiers. We have Amy Ichikawa, Vanessa Gutierrez, and Heather Kelly. And we'll begin with Amy. Please go ahead.
Thank you, Commissioners. My name is Amy Ichikawa. I'm a founding member and the executive director of an organization called Woman to Woman, where I work directly with women in prison across the country. I'm also formerly incarcerated. I'm speaking in opposition to HB 1399 specifically because of the language that was slid into the last paragraph. Section 15 would repeal authority's ability to house people under arrest separately. This non-definitive language is going to put all incarcerated individuals in danger by disabling law enforcement from being able to do the most important part of their job, which is to keep people in their custody safe. There are many reasons why separation is needed in a carceral setting. It would be completely negligent to house people from rival gangs together, to house victims and abusers together, co-defendants, to house reproductively compatible individuals together, for example. This loosely worded terminology is going to end up costing your state a lot of money. Lawsuits will be filed for negligence, pregnancies will be costly, prophylactics will need to be readily available. There will never be enough mental health services available to help the incarcerated population cope with the trauma that will definitely ensue if this becomes law. I strongly urge the committee to please vote no on HB 1399.
Thank you very much.
Thank you. Thank you so much. And we'll now turn to Vanessa. Please go ahead.
Thank you. Good afternoon, Chair Ormsby and members of the committee. My name is Vanessa Gutierrez. I am co-deputy director of the Northwest Immigrant Rights Project, a statewide legal services organization. I'm testifying in strong support of House Bill 1399. House Bill 1399 is an important bill for the immigrant communities of Washington State. It will ensure that professional standards for law enforcement leaders are updated and that they apply to all law enforcement leaders across the state. Law enforcement officers' interactions with communities that lack permanent immigration status are important for cooperation, safety, and protection. Yet today, many fear they may not be protected during calls for help, and that instead some in state and local law enforcement will work with federal immigration enforcement agents despite our state's constitutional and legal protections. Enhancing the standards of professionalism and updating these laws will help build the trust with immigrant communities, especially during these times. This bill is one more step along with others you have taken to help ensure that all community members in Washington State are protected. Thank you.
Thank you.
Thank you. And we'll now turn to Heather. Please go ahead.
Good afternoon, Chair Ormsby and Ranking Minority Member Couture and committee members. My name is Heather Kelly, and I'm here on behalf of the League of Women Voters of Washington, a nonpartisan organization with members and supporters in every county of the state. Let's refocus. This bill is common sense legislation that advances good government and democratic principles and will enhance public trust and confidence. That's why the League of Women Voters strongly supports it. The bill strengthens and aligns standards and eligibility requirements for law enforcement agency leaders. Standards will be the same regardless of where you live, whether you have a police chief or sheriff, whether that person is elected or appointed, whether they share your politics or not. And that matters to the League. Among other things, these standards will ensure that the people in charge of enforcing the law do not have a history of violating it. have not committed serious misconduct, are old enough to have completed their cognitive development, and have a high school diploma. And it makes clear that law enforcement leaders must maintain their certification and their eligibility to serve throughout their tenure in office, providing a clear process for steps to be taken by local governments if certification is revoked due to serious misconduct.
Thank you.
Thank you. And those are all our testifiers.
Oh, thank you, Vice Chair Macri. That will conclude the public hearing on Substitute House Bill 1399. And we now request a staff briefing on Substitute House Bill 1462. I believe we have Mr. Lipson and Mr. Jones returning. Welcome back.
Thanks again, Mr. Chair, members of the committee. Jacob Lipson, staff to the Environment and Energy Committee. As brief background, the state of Washington in the last 5 or so years has enacted several policies addressing hydrofluorocarbon or HFC gases, which have various industrial, commercial, and residential uses in refrigerating and air conditioning, among other things. The state's programs in this front include a refrigerant management program applicable to certain large stationary users, as well as establishing restrictions on certain high GWP or global warming potential refrigerants in certain uses. The bill in front of you has 3 main components. First, it prohibits the servicing of state-owned equipment, stationary equipment with virgin hydrofluorocarbons with a global warming potential of more than 750 beginning July 1, 2026. Exemptions from this requirement could be granted. Second, the bill puts in place a series of global warming potential limits for virgin bulk hydrofluorocarbons in general commerce in the state. Again, exemptions could be granted by the Department of Ecology, and Ecology would also be authorized to adopt rules to reduce these GWP limits or to move deadlines up if it finds that adequate supply of reclaimed refrigerant in Washington exists. And third, the Department of Ecology must establish a refrigerant transition task force to study a transition to low and ultra-low global warming potential refrigerants. After the conclusion of this task force's work in 2027, the Department of Ecology would have the authority to adopt rules to set additional global warming potential limits to require a limit of 10 or 150 for certain sectors if it found unless it found that it wouldn't be practical for a sector to comply with such a requirement. Violations of those global warming potential limits would be subject to the same Civil and Criminal Clean Air Act penalties that apply to other hydrofluorocarbon restrictions.
Thank you.
Good afternoon again. Dan Jones, staff to this committee. This bill has potential costs across a number of agencies, both operating and capital. Much of it is indeterminate. To start with basic implementation of the bill, Ecology assumes costs out of the Model Toxics Control operating account. There's about $500,000 per biennium for managing the task force and the related report and implementing the prohibitions on certain HFCs. Ecology also has about $900,000 in rulemaking costs in 27-29 biennium. Then there are costs at DES out of their dedicated account of around $200,000 per biennium for reviewing exemptions to restrictions on HFCs. And then there are the costs of the policy that state agencies must fix leaking equipment and can't use HFCs over a global warming potential of over 750 unless they are reclaimed HFCs. Agencies that own a lot of cooler equipment and HVAC systems would be impacted by this policy, including the state's colleges and universities, the Department of Corrections, DES, and some of the natural resource agencies. Overall, these agencies assumed that they would have higher costs for using reclaimed HFCs rather than virgin HFCs, and possible equipment replacement costs or building modification costs, in some cases to accommodate reclaimed HFCs, as well as additional staff to inventory or maintain that equipment. As I said, these costs are mostly indeterminate and would be both the operating and capital budget, and that concludes my remarks.
Thank you both very much. Are there any questions for Mr. Lipson or Mr. Jones? Thank you for the briefing. We'll now go to public testimony. Vice Chair Macri.
Thank you, Mr. Chair. We'll start with our, we'll bring up our 2 in-person testifiers, Tiani Tong, Matthew, and Carolyn Logue, and then online we'll bring in Christina Starr and Rebecca Robinson. And, oh, Kate, you're here in the room. And Kate White-Tudor, please come up to the testimony table. And we will begin with you, Matthew. Welcome.
Good afternoon, members of the committee. Thank you for allowing me to testify on this bill. My name is Tianyi Tong, and I am a senior at Lake Washington High School. Climate change is an urgent matter in all our lives. It doesn't just mean we will experience warmer temperatures, but we will also experience more extreme weather events. Like in October of last year when we had Hurricane Milton, the second most powerful hurricane recorded in the Gulf of Mexico. Furthermore, we had a bomb cyclone in December that caused an estimated $18 million of damages to public infrastructure. This is why I believe this bill is essential, as hydrofluorocarbons on average trap heat hundreds to thousands of times more than CO2. We need to reduce these emissions that come from common household items like refrigerators and conditioners. Otherwise, in the foreseeable future, we might not be able to enjoy the great outdoors and the activities that it brings. Because of that, I am in strong support of this bill. Thank you for your time.
Thank you.
Thank you so much. Carolyn, welcome.
Thank you, Mr. Chair, members of the committee. For the record, my name is Carolyn Logue. I'm here on behalf of the Washington Air Conditioning Contractors Association, and I also represent the Washington Food Industry Association, your independent grocery stores. Both organizations are other on 1462. There is still a lot of angst in the business community about the availability and cost of reclaimed refrigerants once these bans go into place. Excuse me. And in the contractor world, we're already working to do these types of, to recover this refrigerant when it comes out, because there's already significant federal penalties for doing so. And often when we do take this refrigerant back, if it can't be used, we receive bills sometimes in the multiple thousands at the contractor level for destruction. We need to end some of these practices, and that's why in the bill right now, we are going to be focused today mostly on making sure that task force has the right individuals at the table to inform how this goes forward so that we can make sure that it is implemented successfully and that it actually results in there actually being a supply of reclaimed refrigerant in the state that is affordable for everyone who still needs this. These systems are built to last multiple decades sometimes, especially your larger systems, and we must be able to continue to service them. So we appreciate any work we can do to make that easier and more effective. Thank you.
Thanks, Kate. Welcome.
Thank you, Chair Ormsby, Representative Mackey, Representative Couture. I'm Kate White-Tudor, testifying in strong support of this bill for the Natural Resources Defense Council. There will be some overarching comments later, but I'm speaking directly to the fiscal note. We're going to fix a drafting error to bring the ecology note down. I've reached out to multiple state agencies to explain this refrigerant transition is global. We're not creating it in this bill, and there is nothing in this bill that requires anyone to change out their equipment before it's used its useful lifetime. There's apparently still confusion about this. We intend this bill to help people use that equipment for its full lifetime by boosting the supply of refrigerants they need for service. There's a couple other charges that are not germane to the policy in the bill that are included in the fiscal note, and we just believe that capturing and reusing refrigerant is a critical security issue. Most of these new HFCs are imported from overseas, and we cannot count on stable supplies. So I urge you to pass this bill. Thank you.
Thank you.
Thank you all very much. And now we're going to turn to our online testifiers, beginning with Christina. Please go ahead.
Good afternoon, Chair and committee members. My name is Christina Starr, and Senior Manager at the Environmental Investigation Agency, or EIA, and I'm here to offer our strong support for SHB 1462. EIA is a nonprofit with decades of experience in this area related to HFCs. And as you just heard, HFCs are potent greenhouse gases that are now under a national and global phase down. This bill will support the economically sustainable implementation of that phase down in Washington state. And for that, we need two things. First, a market mechanism to help recover and reuse the existing HFCs as much as possible, and to reduce our reliance on the new HFCs, which are largely produced in China. Secondly, we need to become independent from HFCs altogether by adopting alternatives in our new equipment. This bill will help accomplish both of these salient goals and ultimately be a win-win for the economy and the environment. We also want to thank the sponsor for the broad swath of industry and environmental stakeholder discussions that have taken place in recent months. We believe that's made this bill stronger and will minimize fiscal impacts to the state. Thank you so much for the opportunity.
Thank you so much. And Rebecca, please go ahead.
Hi, good afternoon.
I'm Rebecca Robinson, testifying in strong support of this bill for PCC markets. We operate 15 grocery co-op stores in the Puget Sound area, serving 120,000 active members. We care about the climate crisis and have maintained carbon neutrality in our store operations since 2018. Refrigeration is key to food safety. So much of what we sell has to stay cold from the day it's harvested through packing and transportation to our display cases. We support this bill for business reasons. The EPA is phasing down imports of new refrigerants from China. I worry we won't have enough. This bill helps grow the market for recycled refrigerants by having the state buy it first. We look forward to doing the same. The bill also manages the transition to climate-friendly refrigeration systems. PCC is proud of installing CO2-based refrigeration systems in 6 of our stores. They are working well. Our power bills have gone down, and our climate footprint has gone down too. Thank you.
Thank you.
Thank you so much, and those are all our testifiers.
Oh, thank you, Vice Chair Macri. That will conclude the public hearing on Substitute House Bill 1462, and would ask for a staff briefing from Mr. Pringle on House Bill 1467. Good afternoon.
Good afternoon, Chair Ormsby, committee members. My understanding is that you would like me to brief the proposed substitute bill to this.
Brief the substitute bill, Mr. Pringle?
The proposed substitute in your EBB is H1369.1 by Representative Ormsby. Essentially, this differs from the original bill in that it corrects some significant technical errors in the original proposal. What proposed substitute House Bill 1467 does is it reamortizes the cost of the benefit improvements that have been granted in recent years and may be granted in the future to members of the Public Employees Retirement System Plan 1 and Teachers Retirement System Plan 1. Currently, those improvements are amortized over a 10-year period, and this would extend that to a 15-year period. In addition, it modifies the basic contribution rates for the PERS, TERS, SERS, PSERS, and WISPERS systems, or Washington State Patrol Retirement System, that were adopted by the Pension Funding Council. And between these two changes, there are reduced contribution rates in the short term and then increased projected future contributions. And so very briefly, by way of background, the Pension Funding Council adopts contribution rates for the state retirement systems with the exception of Left Plan 2. And as part of changing assumptions back in 2021, the Pension Funding Council adopted a strategy of phasing in higher costs created by the changes in assumptions. And this phase-in was to take place over 6 years, with the upcoming 2 biennia being those that would complete that phase-in. The unfunded liabilities in PERS 1 and TERS 1 are supported by 2 separately calculated contribution rates. One is sort of for the base liability for those plans, and those liabilities are expected to be paid off during the upcoming biennium. And there's also a benefit improvement rate, as I mentioned, for those benefit improvements like those one-time Plan 1 COLAs that have been passed in recent years. So the proposed substitute bill reamortizes those improvement rates over a 15-year period, and this reduces the PERS rate for that from 0.55 to 0.26% of pay, and the TERS rate is reduced from 1.1% to 0.51%. And the Plan 2-3 employer and employee contribution rates are changed as well. And I think maybe rather than reading off a very long list of incremental changes in rates, I would point you to the lists of those on my summary, starting there with the Plan 2 and 3 employer contribution rates adopted by the Pension Funding Council are modified by the following ways. It also includes the impacts to the employee contribution rates, because that portion of the bill affects both the employer and the employee rates. With that, a fiscal note is included in your electronic bill book, and it was prepared for an identical technical fix substitute that was run in the Senate. And it indicates a reduction of total state contributions of about $258 million during the 25-27 biennium, with about $198 million of that being from the State General Fund, and another $140 million in total funds, $115 million general fund state in the 27-29 biennium. Now, over the long term, the 25-year estimate, which the state actuaries included for this bill, has a total increased anticipated costs of about $600 million in total state funds, $292 million general fund state. So that would be the amount netted against those savings in the first 2 biennia.
that concludes my remarks.
Excellent. Thank you, Mr. Pringle. Are there any questions? No questions. Thank you very much. And we'll go to public testimony. Vice Chair Macri.
Did you want Joe to stay? Great. We have 2 testifiers in the room, and I will note that Luke Massenling from the Office of the State Actuary is here if folks have questions. But we'll call up Emmett Mills and Sherry Sawyer. And Luke, you're welcome to come up if you like, but you don't need to.
Chair Ormsby and members of the committee, Emmett Mills representing the Washington State School Retirees Association and testifying against House Bill 1467. While this bill's 15-year reamortization of employer obligations to TERS 1 and PERS 1 would provide short-term savings, it would also increase long-term costs. We prefer a different approach that would provide substantially more savings in the short term and the long term. Substitute Senate Bill 5085, which passed Senate Ways and Means last week, would save the state $600 million over the next 4 years and $800 million in the long term. These savings would be accomplished by merging TERS 1 and PERS 1 with LEF 1, which is substantially overfunded. The Senate proposal would also fund an ongoing COLA for TERS 1 and PERS 1 retirees, who are primarily women and the state's only public sector retirees to not receive ongoing COLAs. Instead of advancing this bill, please take a look at Substitute Senate Bill 5085. Thank you.
Thank you.
Thank you. Go ahead, Sherry.
Good afternoon, Chair Ormsby, Ranking Member Couture, members of the committee. I'm Sherry Sawyer. I'm with the Office of Financial Management here today in support of House Bill 1467. Really want to thank Representative Fitzgibbons for sponsoring the bill, and especially want to thank staff for their expertise in the proposed substitute that you have before you today, making what I think were deemed significant technical corrections. So thank you. Really here to answer any questions you may have.
Thank you.
Great. Thank you. Those are all our testifiers.
Oh, well, thank you, Vice Chair Macri. That will conclude the public hearing on House Bill 1467. And now ask for a staff briefing on Substitute House Bill 1497 from Mr. Lipson and Mr. Jones. Welcome back.
Thanks again, Chair Ormsby, members of the committee. Again, Jacob Lipson, staff to the Environment and Energy Committee. His background in both 2022 and 2024, legislation was enacted addressing organic materials management, including food waste reduction and composting programs and requirements. In the 2024 iteration of the Organics Bill, one thing that was included was the establishment of a new grant program to provide for costs borne by local governments and businesses to implement those organic material management policy requirements from the 2022 and 2024 laws. The bill in front of you, Substitute House Bill 1497, does a number of different things. First, it establishes new requirements for the coloring of new solid waste collection bins beginning in 2028 and establishes labeling requirements for solid waste collection bins beginning in 2027. There are not penalties for violations of these requirements. However, entities that are not in compliance with coloring requirements would not be eligible for the grants that I mentioned that were established as part of last year's law. Second, subject to appropriation, the bill requires the Department of Ecology to carry out a contamination reduction and outreach program. Third, it directs the Department of Ecology to develop and publish a list of businesses that are expected to be subject to organic material management requirements under the 2022 and 2024 laws. Those would be used by local governments and solid waste collection companies. Fourth, the bill establishes penalties for violations of business organic material management service requirements that were first established in 2022. These penalties would be imposed by jurisdictional health departments or local governments that are implementing a local solid waste plan. Fifth, the bill requires local governments to phase in, as part of their local solid waste planning processes, organic material service requirements for multifamily residences, which were excluded from the previous organic material collection service requirements in the 2022 and 2024 laws. There's also a piece that directs the State Building Code Council to adopt a building code that facilitates the collection of source-separated organics materials. And finally, the bill adds food waste reduction to a couple of existing programs focused on Washington-grown produce in K-12 schools, and directs the Office of the Superintendent of Public Instruction to develop open educational resources for use by schools related to food waste reductions.
Thank you.
Good afternoon again. Dan Jones, staff to this committee. The Department of Ecology fiscal note estimates their costs at $1.2 million next biennium and $1.6 million the following biennium out of the Model Toxics Control operating account. Around 2/3 of that cost is for education and outreach related to residential source separation. Other costs for ecology include an annual list of businesses that are required to manage organic materials and technical assistance to local governments. There are costs for the Office of Superintendent of Public Instruction for food waste reduction grants, which are subject to appropriation, as well as creating materials on food waste for schools, but the OSPI fiscal note is not yet available. The Environmental and Land Use Hearings Office assumes costs of around $120,000 per fiscal year from General Fund State for hearing appeals of penalties, and there'd be some indeterminate costs to local governments for reporting performance data to ecology and conducting outreach on new waste bins. That concludes my remarks.
Thank you both very much. Questions for Mr. Lipson or Mr. Jones? No questions. Thank you. And we'll now go to public testimony. Vice Chair Macri.
Thank you, Mr. Chair, and we'll call up our in-person testifiers to come to the testimony table. Heather Trim, Kate White-Tudor, and Rick Vall. And then we will get ready online, Erin Ganau. I'm sorry if I mispronounced that. And we will start with Kate. You're ready. Please go ahead.
Sure, thank you. Chair Ormsby, members of the committee, I am Kate White-Tudor, testifying in support for the Natural Resources Defense Council, otherwise known as NRDC. NRDC works at the federal, state, and local levels with partners to prevent food from going to waste, to rescue and redistribute surplus food, and compost food scraps to help build healthy soil. Across the nation, about 24% of the load to landfills and incinerators is food, and it's critical that we reduce this load because this organic material rots in landfills, generating methane, which is 80 times more potent as a climate pollutant than carbon dioxide. There are currently 10 states with organic waste bans. I can list them if you want to know, and we are already seeing significant food waste reductions in those states. So we support this bill. It includes policies to help create more diversion. It addresses issues with multifamily housing, and it's got strong programs to educate our students and our future, who are our future stewards of this program. Thank you.
Thank you.
Good afternoon, Chair Ormsby and committee members. Heather Trim with Zero Waste Washington. I'm going to be brief. This bill, led by Rep. Dolio, builds on the previous work to get that oozy-goozy food into compost and to get it clean. That's what we really need to do, to get it out of the landfill and have it stop creating methane. And in terms of the fiscal note, I've been discussing with Rep. Dolio how to make some cuts to get that note down.
Thank you.
Good afternoon, Chair Ormsby and members of the committee. Since I just heard the word oozy, I am distracted, and I do want to testify in support of the bill. Once again, my name is Rick Vall with Waste Connections. We provide service collection throughout the state for organic collection, food waste, and other organic materials. We also process it and market the compost, so we under it every level where the ooze is coming from. I do want to say there was a tremendous amount of work that happened in the policy committee, and I want to thank Representative Dolio for understanding our concerns with the implementation challenges and the cost associated with some of the changes. So substitute House Bill 1497 is at this time what we support. It's those changes that helped us move to this position. Appreciate it.
Thank you.
Thank you all. And now we'll turn to Erin online. Please go ahead.
Hi, everyone. My name is Erin Gagnon, representing DTG Recycle, testifying in support of this bill. We are a company dedicated to improving the circular economy. We employ about 600 people, operate about 400 trucks, handling primarily construction, demolition, recycling, although a few years ago we did acquire an organization that's an organics company located in the Kitsap Peninsula that would be directly impacted by this bill. We are committed to advancing organic recycling management and support this bill. We appreciate this bill helps support additional outreach services and standardized container coloring, which we hear about a lot from our customers. We also continue to support improved organics collection as it helps reduce greenhouse gas and improve sustainability initiatives statewide. Thank you, and I'm happy to stand for any questions.
Thank you.
Thank you. Those are all our testifiers.
Okay, thanks, Vice Chair Macri. So that will conclude the public hearing on Substitute House Bill 1497, and would ask for a staff briefing on Substitute House Bill 1524. I believe we have Ms. Lee in the room and Ms. Leonard joining us online. Good afternoon.
Good afternoon. For the record, Kelly Leonard, Counsel to the Labor and Workplace Standards Committee. Substitute House Bill 1524 relates to isolated employees. For some context, in 2019, the state established specific requirements for employers of isolated employees, which includes any janitor, security guard, hotel or motel housekeeper, or room service attendant who also spends a majority of their working hours alone or whose primary work responsibility involves working without another coworker. A hotel, motel, retail, or security guard entity or property services contractor who employs one or more isolated employees must currently adopt a sexual harassment policy, provide mandatory training to its employees, and provide isolated employees with panic buttons, with exceptions for security guard companies. Substitute House Bill 1524, as recommended by the Labor and Workplace Standards Committee, does four things. First, the bill modifies the definition of isolated employee to mean any janitor, security guard, hotel or motel housekeeper, or room service attendant who either performs work in an area where two or more coworkers, supervisors, or a combination thereof are unable to immediately respond to a call of distress or emergency, or who spend at least 50% of their working hours without a supervisor or another coworker present. Second, the bill expands requirements for panic buttons, including providing training and maintaining records, and specifies required features for panic buttons. Third, the bill makes failure to provide a panic button to an isolated employee in accordance with the requirements in the bill an unfair practice under the Washington law against discrimination, effectively allowing for enforcement by filing a complaint through the Human Rights Commission or through a private right of action. And fourth, it directs the Department of Labor and Industries to enforce all of the requirements pertaining to isolated employees. L&I may order the employer to pay a civil penalty of $1,000 for each willful violation of requirements and $2,000 or more for each repeat willful violation. But L&I may waive or reduce the civil penalty if it determines that the employer has taken corrective action. I'll defer to Sean Yu to provide a fiscal analysis of the bill.
Thank you.
Good afternoon, Mr. Chair, members of the committee. For the record, I'm Shen Yu Lee. Moving to the fiscal impact, there's a fiscal note in your ABB. The Department of Labor and Industries assumes costs of about $1 million in 25-27 biennium, $396,000 in 27-29 biennium, and beyond for staffing costs, IT system updates, and legal services paid by L&I's dedicated accounts, accident account, and medical aid account. L&I would need 2.3 FTEs in 25-27 biennium, 1.7 FTEs in 27-29 biennium, and thereafter to manage a projected 113 additional complaints annually. For the cash receipts impact, L&I has the authority to issue penalties related to the violation of this act. Because the penalty amounts can vary, the cash receipts impact is indeterminate. The Office of Attorney General assumes a cost of $18,000 per fiscal year for 0.7 FTE to provide legal services to L&I and plans to bill L&I for costs through their legal services revolving account. Fiscal note for the Human Rights Commission is just requested today, for the Commission might have additional costs due to the increased complaint. And that concludes my remarks.
Excellent. Questions for Ms. Leonard or Ms. Lee? Representative Caldier.
Thank you, Mr. Chair. So does this just apply to private industries, or does this also apply to state employees?
I think Callie would be better to answer that question.
Yeah, the bill does not make any distinction between private and public employers. The requirements for isolated workers are current law, so it's an expansion upon that. They do have to meet certain requirements in terms of certain occupations and spending a certain amount of time of their workday alone in order to meet that threshold. So I don't have any information as to how many public employees that would apply to.
Thank you. Are there any other questions of our policy and fiscal analysts? Seeing none, thank you both very much for the briefing, and we'll now go to public testimony. Vice Chair Macri.
Thank you, Mr. Chair. We have two in-person testifiers, Khalil Hamaduddin and Julia Gordon.
Good afternoon and welcome.
Would you like me to go first?
Okay, great. Thank you, Chair Ormsby and members of the committee. I'm Julia Gorton here today on behalf of the Washington Hospitality Association. We support House Bill 1524, but oppose the substitute before you today. Our industry supported the original bill to provide panic buttons to employees working alone, and we support giving L&I the tools to enforce compliance. However, we oppose the new Section 2, which makes non-compliance a civil rights violation. Washington's law against discrimination protects against intentional discrimination based on race, creed, gender, and other protected classes, not workplace safety compliance. There's a very clear difference between an employer unknowingly failing a safety standard and violating a constitutional protection. We believe it's appropriate for L&I to investigate, educate, and impose significant penalties if needed, but allowing a private right of action with uncapped statutory relief is excessive and should be reserved for civil rights violations. For this reason, we ask that you remove Section 2 or not advance the bill. Thank you.
Thank you.
Thank you. Welcome, Khalil.
Good afternoon. My name is Khalil Hamiduddin. I'm with the Labor Union SEIU 6. Thank you, Chairman and members of the committee, for granting me the opportunity to speak today in strong support of House Bill 1524. This bill is a critical step towards safeguarding the lives of vulnerable workers in janitorial and security roles, workers who often face heightened risk due to the isolated nature of their jobs. It builds on the 2019 Isolated Worker Protection Act, which mandated panic buttons and sexual harassment training. However, without the enforcement mechanism, too many employers have neglected their duty to ensure a safe workplace. This bill addresses this gap by introducing enforceable measures to hold companies accountable. By supporting this legislation, you are not just upholding workplace safety, you are standing with those who are most at risk. Let us continue to protect Washington workers and lead by example in prioritizing dignity and safety for all. Thank you for your time.
Thank you.
Those are all our testimonies.
Thank you, Vice Chair Macri. That will conclude the public hearing on substitute House Bill 1524. I would now request a staff briefing on substitute House Bill 1565. I believe we have Ms. Allison and Ms. Henry joining us. Good afternoon.
Good afternoon, Mr. Chair, members of the committee. For the record, Elizabeth Allison, staff of the Post-Secondary Education and Workforce Committee. 1565 is the bill before you, continuing the Washington Dual Enrollment Scholarship. For some brief background, dual credit programs allow high school students to earn high school and post-secondary credit at the same time. The Washington Dual Enrollment Scholarship Pilot Program was established in 2019 for students who qualify for free or reduced price lunch, are enrolled in one or more dual credit programs, and have at least a 2.0 grade point average to receive a scholarship. Under the pilot program, the Office of Student Financial Assistance, or the office, within the Washington Student Achievement Council may provide scholarships for Running Start students. The award must cover mandatory fees, prorated based on credit load, course fees and laboratory fees, a textbook voucher to be used at the institution's bookstore, and apprenticeship materials. The textbook voucher must be worth $10 for each credit per quarter the student is enrolled, up to a maximum of 15 credits per quarter or the equivalent per year. If the pilot program is not renewed by the legislature, following the sunset review, the pilot program is set to expire July 1st, 2025. Turning to the bill, eligibility for a scholarship under the program is expanded to include students who qualify for public assistance food benefits, the College Bound Scholarship, and the Washington College Grant. The requirement that a student have a minimum grade point average of 2.0 to participate is removed, and instead the office is directed to adopt rules regarding grade point average requirements. The textbook voucher is changed to a voucher for required course books, materials, and supplies. The maximum amount and credit load is removed. The amount of the voucher is to be determined by the office in consultation with the State Board for Community and Technical Colleges and participating institutions of higher education. Apprenticeship materials are expanded to include professional and technical program materials and pre-apprenticeship program materials. If sufficient funding is available after those materials are covered, a basic needs stipend for food and transportation may be provided. The amount of the basic needs stipend must be determined by the office in consultation with the State Board for Community and Technical Colleges and participating institutions, and institutions must report to the office on the basic needs category for which the stipend was used. The office is directed to adopt rules to implement the program by January 1st, 2026. And finally, by October 30th and annually thereafter, the office is required to submit a report to the legislature with a summary of the amounts and purposes for which scholarships were awarded under the program.
Thank you.
For the record, Kate Henry, staff to this committee. There is a fiscal note in the EBB for the substitute. There is an appropriation in the bill of $750,000 for both fiscal years 26 and 27 for the scholarship. Additionally, the fiscal note estimates that WASAC would require $38,000 each year of the pilot and $37,000 one time in fiscal year 26 to establish the program through work group meetings, and the assumption that funding for these scholarships would be allocated to institutions rather than award scholarships directly to students. Eastern Washington University, as a current pilot site, estimates that $15,000 per year is needed to administer the program on campus, and Central Washington University assumes an additional $3,000 per year for the expansion of eligibility. If the administration is on top of the appropriation included in the bill, the fiscal year estimate is $1.6 million NGFO for the 25-27 biennium, and if the $750,000 is continued, then it would be $3.2 million for the 4-year. And that concludes my remarks.
Excellent. Thank you both very much. Questions for Ms. Allison or Ms. Henry? No questions. Thank you. We do not have anyone signed up to testify on 1565, so that will conclude the public hearing on Substitute House Bill 1565. And sorry, ladies, if we could get Kate and Elizabeth back for the next. I should have looked down and seen you were both briefing the next bill, and you wouldn't have had to get up and come back.
Got to get our steps in.
Yeah, okay. Thank you.
Good afternoon, Mr. Chair and members of the committee. Once again, Elizabeth Allison, staff to the Post-Secondary Education and Workforce Committee. The bill before you now is Substitute House Bill 1587, encouraging local government partner promise scholarship programs within the Opportunity Scholarship Program. For some background, the Washington State Opportunity Scholarship Program was established in 2011 to provide scholarships to low and middle income resident students pursuing eligible high demand baccalaureate degrees in science, technology, engineering, and mathematics, and healthcare, and to encourage scholarship recipients to work in the state upon completion of their degrees. The Opportunity Scholarship Board is staffed by a program administrator. The Opportunity Scholarship is a private-public match program in which the state matches any private contribution in order to fund the scholarships. The state match is capped at $50 million annually. By December 1st of each year, the Opportunity Scholarship Board must report to the governor, the legislature, and the Student Achievement Council on various metrics, including the number of applicants, the total amount of private contributions, and the total amount of state match funds. Turning to the bill, a local government may establish its own local government partner promise scholarship program within the Washington State Opportunity Scholarship. Local government partners could include municipalities, counties, or federally recognized Indian tribes. The promise scholarship must be administered by the Opportunity Scholarship, which must assist the local government partner in the selection, notification, and disbursement of the scholarship awards. To be eligible to participate in a promise scholarship, a student must have received his or her high school diploma or high school equivalency certificate in Washington, and attend a public 2-year institution of higher education or a professional, technical certificate or degree program in an education program at an institution of higher education. A local government that establishes a promise scholarship may adopt separate rules for its program that are independent of the broader Washington State Opportunity Scholarship Program. The promise scholarship award amount at minimum must be the difference between the recipient's total tuition and fees minus any state aid. State matching funds are limited to $300,000 for each promise scholarship. If there are not enough funds to serve all eligible applicants, priority must be given to applicants to the broader Washington State Opportunity Scholarship Program over applicants to a promise scholarship program. Beginning in 2025, the Education Research and Data Center must provide data on the outcomes of Washington State Opportunity Scholarship Program recipients and graduates by November 1st of each year. The annual report must include the total amount of private contributions and state match money received by promise scholarship recipients and the total number of students served by each local government promise scholarship.
Thank you.
Again, Mr. Chair, Kate Henry, staff to this committee. There is a fiscal note in the EBB for the substitute. Currently, the state matches the private donations made on a one-to-one match at roughly $8 million per year for the Opportunity Scholarship. The statute has a limit of $50 million per year in state match, and the fiscal impact would vary on the number of local governments pledging money for the purposes Elizabeth laid out. Communicating with the Opportunity Scholarship Program, I am aware of 2 localities wanting to receive the match, both Renton and Tukwila. Seattle is already receiving a match under the existing program, and the cities would result in up to $600,000 per fiscal year and could drastically increase based on participation. So the known fiscal impact would be $1.2 million for the 25-27 biennium, with an unknown 4-year number depending on participation. And that concludes my remarks.
Excellent. Thank you both, and thank you for your patience. Are there any questions for our policy and fiscal analysts? No questions. Thank you. We'll go to public testimony. Vice Chair Macri. Oh, I'm so sorry. I did not ask our prime sponsor, Representative Berquist, if he'd like to make some introductory remarks for this policy.
Well, thank you, Mr. Chair. Real brief remarks. The government match program that was established quite a few years ago has had one government organization take advantage of it one time for $200,000. I think it's an opportunity to help kind of work with government partners as we're expanding opportunities for students. I know that there's opportunities in quite a few jurisdictions, but I think limiting it to a few $100,000 as a max. I know right now there's about $250,000 this year that would be matched. The deadline's already passed, and you know, going forward, maybe it would be great to have a few more partners.
Thank you, Representative Berquist. And now we'll go to public testimony. Vice Chair Macri.
Thank you, Mr. Chair. We have two testifiers, one in person, Ben Mitchell, if you can come up, and then online, John Axtell.
Good afternoon.
Hi, good afternoon. Thank you, Chair Ormsby, Ranking Member Couture. For the record, my name is Ben Mitchell. I'm Director of Policy and Advocacy at Foundation for Tacoma Students, testifying in support of House Bill 1587. So we have in our state the best need-based financial aid programs for post-secondary education in the country. And what that enables us to do at the local level is think about what kind of last-mile complements do we want to put in place to help meet unmet student needs. And we've been doing this in Tacoma. We've been working with the Mayor's Office, the City Council, Pierce County government to develop the framework for a Tacoma Promise program. We're excited about it. One of our biggest challenges is figuring out how to pay for something like this. House Bill 1587 would help efforts like ours at create a viable or help make our financing options more viable. WSOS is a great program. Their existing government partnerships is a great option for localities like ours. HB 1587 would give us additional optionality and a little more flexibility to consider at the local level. Thanks to Representative Berquist for his development on this bill and the team at WSOS, and urge your support.
Thank you.
Thank you very much. And John, welcome back. Please go ahead.
Thank you. May I ask a point of order, Madam? Both Carolyn Frey and myself on the computer show signed up for 1565, and neither of us were called. So I would ask you to
I'm sorry about that.
Yeah, my apologies, Mr. Axtell. Will, if you would like to make comments to 1587 and then separately to 1565 when you've concluded. Sorry for the oversight. Go right ahead.
Yeah. And hopefully Carolyn can do the con. Okay, on 1587, thank you. John Axtell, student advocate. Anything you can do to help students attend college and reduce their debt load is greatly appreciated. I still think there should be a GPA expectation to receive a scholarship, but understand that's a problem. I don't think the GPA should be required to get it, but to keep it. Tuition is not the largest expense in attending college. It is the need to work to pay for living expenses that impact GPA. Students do not attend the K-12 system voluntarily. They are conscripted. Once students choose to pursue a path, that is when results happen. I believe that the high school GPA should not be a barrier for a scholarship. Thank you very much.
Thank you, Mr. Axtell. And if you would like to make remarks on 1565, please go ahead.
Thank you, sir. Our K-12 system is extremely ineffective. Any opportunity you legislators have to enable students to have alternatives that want a better education, I encourage you to create. I may not understand all the issues. That's why you're elected to be legislators. I don't understand why the 25 pages of people indicating con. Each year, the primary and middle school attend in my district lose ground compared to the peers. For every college credit earned, those enlisting in the military may get a higher pay rate. For those with an AA, possibly a higher rank. So anything that you can do to not block kids that maybe really messed up in high school and get into the 11th and 12th grade and do scholarships and get them out of the high school courses that they don't want would be greatly appreciated. Thank you for your time and your attention to the details. Thank you.
Thank you. And I believe
Tara Lynn Frey.
Tara Lynn.
She is signed in on, as John said, on a couple different bills, but she is not present.
Okay, thank you for pursuing that, Vice Chair Macri. And that will conclude the public hearing on Substitute House Bill 1587. And now I would ask Mr. Pringle to give us a staff briefing on House Bill 1936. Welcome back.
Thank you, Chair Ormsby, committee members. House Bill 1936 relates to the teachers' retirement system, public employees' retirement system, and school employees' retirement system. Retirees' eligibility to continue to receive benefits while they engage in certain types of employment. And there are temporary provisions that expanded the number of hours that these plan members could work while they were still going to receive their retirement benefits from 867 hours per calendar year to 1,040 hours until January 1st of 2025. And House Bill 1936 extends those dates to 2027. Very briefly, in 2022, statute was changed permitting these retired members of PERS, TERS, and SERS to work for up to 1,040 hours in a non-administrative position for a school district without suspension of benefits until that 1040 limit. In addition, for TERS members retired before July 1 of 2022, or January 1 of 2022, excuse me, these provisions also applied to superintendent or in-school administrative positions with second-class school districts. There is an actuarial fiscal note. It's not yet in the electronic bill book, but I can tell you that there's no impact anticipated from the bill, as the provisions are only temporary and affect a relatively small number of people. According to DRS, only about 350 retirees have worked beyond that 867-hour threshold that's sort of in the ongoing law.
Excellent, thank you. Are there any questions for Mr. Pringle? No questions, thank you. We'll now go to public testimony. Vice Chair Macri.
Thank you, Mr. Chair. We have two in-person testifiers, John Kalikowski and Devin Gombowski, and then remote, we have Steve Jantz, Dr. Ann Vrakadas, and Lynn Scharf. And Jim, please go ahead.
Good evening, Chair Ormsby and members of the committee. My name is Jim Kokowski. I'm a retired school superintendent, and I'm director of the Rural Ed Center, cooperative over 103 small and rural districts all across the state. Testifying today in support of House Bill 1936, and kudos to Representative Berquist, is basically his bill from a few years ago that we're just asking to extend the dates. As you've heard during the intro, this bill simply extends the sunset date for Class 2 districts to employ retired teachers, long-term subs, custodians, administrators, or other hard-to-fill positions for up to 1,040 hours each school year. There's no additional funding, as you've heard, to the state. In fact, the state will save money because retired administrators who go back to work do not get any benefits, sick leave, or retirement. You're going to hear in a few minutes from two very passionate superintendents who've retired, but they still have fire in the belly and they still want to help their small districts. You're going to hear from one that actually is a superintendent of two different districts. On behalf of Class 2 districts, thank you for this bill. And one last request, there is a Senate bill heard tomorrow. It's exactly the same language, except it extends it for 4 years instead of 2 years. So request maybe to amend this bill so it's the same as the Senate bill. Thank you very much. Much appreciated.
Thank you, Jim.
And welcome. Go ahead, Devin.
Good evening, Chair Ormsby, Ranking Member Couture, and honorable committee members. For the record, I am Devin Gombowski, here today on behalf of ESD 105 Schools Coalition and ESD 112 in strong support of House Bill 1936. I'd like to echo the comments made by Superintendent Kolakowski and just remind you all that this bill provides a financial support to our 1.2 million schools across our students in our 295 school districts, and is a small step to ensure that our students have the educators and ministers that they need to learn. It's a common
sense solution and provides our schools with an invaluable resource, educated professionals who can quickly fill roles ranging from classroom support, bus drivers, and superintendents, as you heard, for Class 2 school districts. This is a targeted and effective response to a pressing challenge, and it enables our communities to tap into a pool of qualified, experienced individuals at a time when every hour counts in keeping our schools open and our students thriving. I want to thank Chair Ormsby and the committee for the financial commitments you have made to our schools in the last biennium, and good luck to you all as you navigate a challenging budget situation.
Thank you very much.
Thank you. Now we'll turn to our online testifiers, beginning with Steve. Please go ahead.
Thank you, Mr. Chair. My name is Steve Giance, and I am the superintendent principal at the Keller School District. We're up on the Sand Boil on the Colville Confederate Tribe. We're made up of a K-6 school, and we're non-high, meaning our 7 through 12 go to Wilbur, Republic, and Grand Coulee. For myself, I've been there 7 years, 2.5 years as principal and superintendent. It's real critical, we feel, to continue to have this bill, House Bill 1936, intact, especially for the 1,040 hours because of the time spent. We only have 11 staff members, and daily we're trying to fill slots as the day goes on. We're very proud of our school. We're proud of the ability to teach our students, and there's just a lot of concern that we don't have people out there to fill these positions. And I'm just going to take the last couple seconds to thank the legislature for your small modernization grant that you put forward a couple years ago. We were able to put in HVAC, lights, windows, and made our school real nice. I just want to thank you for your consideration on this and your time.
Thank you.
And Anne, please go ahead. If you can unmute your microphone and state your name for the record. Thank you.
Hi, thank you, Honorable Chair Ormsby and committee members. My name is Ann Varkatis. I'm superintendent currently of Lisle and Centerville School Districts. I'm here to testify in support of House Bill 1936. As an experienced retired administrator, I'm able to support these two small districts in the Gorge that struggled to find an administrator, a superintendent. Once again, as it's been stated, this request does not impact the state budget, and it helps the small districts due to the prototypical model not covering one full-time administrator. Just so that you know, there are 7 districts in ESD 112 that currently operate with a retire-rehire superintendent, along with substitute teachers, which it's so important to have those substitutes in the classroom. So please, we're begging for passage of House Bill 1936 or Senate Bill 5738. Keeping the allowable hours at 1,040 per year is crucial. Thank you, thank you.
Thank you.
Thank you. And Lynn, welcome.
Thank you, Chair Ormsby and committee members. I'm Lynn Scharf. I'm the Vice Chair of Great Northern School, a K-6 school outside of Spokane. I'm here in support of House Bill 1936. To fill the role of superintendent, you're looking for an individual with specialized qualifications, a limited resource at best. Now, throw in your district only needs a part-time superintendent, and your pool of candidates becomes practically non-existent without the provision to allow retired administrators to work part-time in a second-class district. We have hired active superintendents that we shared with other districts to create full-time positions, with other districts to create a full-time position for the individual. However, we have lost those individuals when full-time positions became available within one district. Consistency and stability are crucial for school districts, and a revolving door of leaders impacts our ability to provide the vital education experience we owe our kids and community. The answer lies within the ability to hire retired administrators. Please support House Bill 1936. Thank you.
Thank you. And that will conclude the public hearing on House Bill 1936. And being no further business before the committee, we are adjourned. Democrats will caucus in B15. B1518.